case number 117395 in the matter of Brandy L. Sutton.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. As the court is aware, the facts really aren't in any kind of dispute. The respondent here engaged in a period of misconduct in which she caused pay stubs to be produced and distributed to her employees that made it appear to look like she was funding their 401k IRA program. And in fact, she was not for a period of time, and then there was another period of time that the deposits were actually sporadic. There was a stipulation and a finding by the panel of 8.4C. And as this court is aware, generally probation is not an appropriate resolution for a lawyer who has been found to have engaged in dishonest or fraudulent conduct. And there are exceptions to that, and in this case, as the court is aware, she did have a probation plan that was in place prior to the hearing. She has filed her affidavit that explains that she's in compliance with that probation plan. And so if this court determines that probation is the appropriate sanction, I would ask that you affirm the panel's recommendation for a 3-year term. But I am renewing my request or my recommendation for a suspension. In doing the analysis, I believe this is a disbarment case. Applying the mitigating factors that involve her mental health, we come to an indefinite, which is my original primary recommendation. And part of that is because it comes with the 219 hearing.
Does that conclude your presentation?
Yes, it does, Your Honor.
I'm not sure I understand why your emphasis on the 219 hearing. I mean, you can get a 219 hearing if we did this for a 1-year suspension or a 6-month suspension or whatever. So you're thinking that the misconduct is so great it deserves indefinite suspension, period. And then it has the benefit of having a 219 at the back end of it.
I do. I looked at the cases that were cited in my brief. I mean, the Schnechter case always kind of comes to the top of my mind. And in that case, he had misappropriated funds from his own partner and was found out and cashed out his 401k, made the partner whole. The partner didn't call the police, but out of his obligation to report, he did. And that individual ended up being disbarred. And in this case, we have individuals that were relying on their boss. There were options. She could have just said, you know what, folks, the economy's tanked. I'm having a hard time. I'm going to have to stop this 401k. And she chose not to do that. We're talking a period of time. And, every 2 weeks, there was a decision made to make a pay stub that reflected something that was not true. And she had been found out, there was a prior lawyer that had left that she had to pay off. Her paralegal confronted her, and she acknowledged to the paralegal that she wasn't able to fund. And then we have the complainant in this case that left and discovered it, and everything came to the forefront.
There's testimony that in front of the hearing panel, and apparently they adopted the testimony that it was really the untreated psychological condition that kind of caused the environment that created the conduct you just described. They acknowledge that. Do you have, my question is once the misdiagnosed treated psychological condition was addressed, was there any ongoing conduct, or did that remedy the difficulties here?
Well, okay, I'm not sure I'm following you. But
Well, once it was discovered that her psychological condition was mismanaged or misdiagnosed, there was a different regime, there was a different form of treatment that was initiated. What, correct? And
yes.
that's correct. Was there, once that occurred, did the conduct continue?
Well, at that time, she was participating with the Department of Labor in their voluntary program. So there was another entity of oversight, just as we have now. And Mr. Anderson reports that he is verifying that everything is being done, that she is fully funding. So I'm not sure I'm answering your question, but she was found out, then she went and got the new treatment regime, and then she participated and fully funded everything through the Department of Labor's voluntary program. And then she has Mr. Anderson looking over her shoulder to make sure everything's okay. So I guess the long answer to that short question was there has been no subsequent misconduct that we've discovered.
Any more questions?
And your recommendation is indefinite suspension?
Yes.
Okay, I just wanted to clarify that. I thought that was unclear. Thanks.
Thank you, counsel.
May it please the court. Daniel F. Church, and I have the honor and pleasure of being before your honors representing Ms. Sutton today. And I would agree with Ms. Knoll that there are many of the facts in this matter are well stipulated too. Ms. Sutton has been a lawyer practicing for 19 years in Lawrence, Kansas. She was admitted in Kansas in 1998 and Missouri in 99. She has no prior disciplinary matters pending or matters against her. She employs 12 people at her law firm. Her law firm is Pendleton and Sutton. She purchased that firm after a few years of practice there. The practice of that law firm is principally real estate and collections. She has one other attorney working with her. She did undertake to develop a simple 401k plan, or an IRA plan, excuse me, wherein 3% of an employee's payroll could be contributed to the plan and that she would match that 3%. That is without question. Each employee receives quarterly from the IRA custodian, which is a separate entity, quarterly statements about the IRA contributions and the status of those contributions. So each employee gets that information quarterly to reflect whether or not contributions have or have not been made to them during the particular period of time. What makes this case difficult, frankly, Your Honors, is that Ms. Sutton did suffer from a substantial mental impairment. And that was and began in 2005. She sought treatment from a medical physician, a healthcare physician, and diagnosed her incorrectly. She was diagnosed with a major depression and given antidepressants as a medication treatment. And that worked for a while, but in 2012, her condition substantially deteriorated. She started having periods of blackouts. She started having mental problems in terms of loss of memory, and anxiety levels were substantial, and she was having difficulty with her practice. In fact, she testified at the hearing that she couldn't maintain her practice and literally turned it over to her paralegal.
And I don't mean to minimize her condition and as a result of being maybe misdiagnosed or that treatment, but did that condition result in her being able to not differentiate between truth and falsehood? I mean, that's really basically what we have here. And did that condition create that?
I think Judge Rhodes, I think it's a great question, and I think the true answer is that there were periods of time when she was manic and she'd used horribly bad judgment, and it did impair her. And there were periods of time when she probably was not. And so I don't think you can just say randomly over the entire period of time that she would be totally impaired. But I think that as the hearing panel found in this case, that they believed, based upon the testimony of the healthcare professionals that we presented for 3/4 of a day of evidence, that they believed that her mental state did substantially impair her ability to recognize the misconduct and correct it.
Did
And I
they
think that's
testify-
significant.
Excuse me, counsel, did they testify that she had periods of mania?
Yes.
Okay.
Yes, they did. And so we presented, and so any rate.
Council, I've got to get about 10,000 feet here. And I've been
Okay.
I read all this stuff a week or so ago and then your plan this morning. But I get confused looking at the facts. Just tell me, what's the period of time involved where the money that the employees were paying in didn't get contributed to the plan? What's that time span, and how much money are we talking about? Aggregate.
2012 was the time period it began, and then in 13 she made full contributions, actually over contributed, and then 14 there was a period where there was some erratic payments. And that was when she was the most substantially impaired and having the most difficulty. In fact, she was hospitalized during that period because of her condition was so substantial. And so
How much money?
the amount of money, I believe it was $22,000 maybe dollars or something to that effect. And in fact,
Does that include her part and the penalties, or is that just the
that
employee
would be the
portion?
penalties or the earnings, lost earnings, and the amount of contribution.
Okay.
And so basically what happened is that there was a complaint filed, and I'm going to move ahead a little bit. There was a complaint filed by an employee of hers, an associate who quit. During that time period, shortly before that, Brandy's grandfather died, who is her father image, and it really impacted her. She couldn't get to see her psychiatrist because he would not see her. He retired. She had to find a new treatment, and that's what she did. And so in early 2015, she sought out the treatment of a different healthcare professional. In fact, she contacted KLAPS asking for help finding somebody. And that was Dr. Alardi, she's a nurse practitioner, Alardi, and she testified. And Alardi was the one that discovered that the misdiagnosis of the depression and the actual treatment of the antidepressants were actually exacerbating her problem because she was actually bipolar, and that she needed mood sensitive treatments and drugs that would affect the bipolar, and that now that she has been on those medications, she has completely reversed her lifestyle, her practice. Her practice is intact. She's maintaining her practice with 12 employees. She's never not made an IRA contribution since she's been diagnosed and receiving the proper treatment. There was a period, I want your honors to know, that's important. When she first started seeing Alardi and was diagnosed with bipolar, it took about a 5 months or 4 month period for the mood sensitive drugs to take effect. And at that period of time, there was an ethics complaint, and I know she filed some responses that were probably not reflective of where she is today. And it was in great part, I think, too, because she had not yet had a chance to begin to recover and take the medications taking effect that allowed her to do so.
So those responses were filed prior to her receiving the medication, or around the
Exactly.
same time when she was really blaming
Right.
her prior employees and employees
Exactly.
for the problem.
And I think she will tell you she recognizes that was inappropriate. I mean, totally. And when she recognized it, that she will not stand here and tell you that she shouldn't have been making those payments and that was inappropriate as well. I think what she would tell you, though, is that she is on the track today, and she's doing everything that a lawyer would do today, that you would want a lawyer to do today. She went and sought out the Department of Labor. When she couldn't reconcile the differences in the IRA payments, we sought out the Department of Labor, and they have a voluntary correction program, a voluntary fiduciary correction program, actually that subjects you to criminal penalties. If they find that you violated the law, they will criminally prosecute you. And this is a voluntary program that she entered into, turned in all of her financial records concerning the payroll or failure to make to the Department of Labor so that they could analyze them and determine what she had done. The Department of Labor, she made full restitution, total payments by January of 2016 under the guidance of the DOL, and with the help of them. The Department of Labor in October of 2016 issued a no action letter, which meant that they found that there was no deceitful, no intentional conduct that violated the laws such that they believed that it warranted civil penalties or any criminal action. So I think the Department
Counsel,
of Labor recognized that she had made an appropriate restitution and turned the corner.
Along those lines,
Yes, Your Honor.
did your client, my understanding is your client prepared the pay stubs?
I believe that is correct.
Okay, so I guess my question is, it strikes me as eminently understandable how a mental disease or these kinds of problems would or could cause a lawyer to fall behind in making payments or actually have the sort of inability to just manage the day-to-day business of law practice. But how does it impair, or how do we view the deliberate falsification of pay stubs as being, I mean, how is that something which is mitigated by the mental health evidence in this case?
I think what you'll hear, and certainly Ms. Sutton's going to address you, but I think you'll hear her address you to suggest to you that she intended to pay these out, that she did never not intend to pay them, that her plan was to pay them. She didn't have the funding available at the time, but she intended to pay them. She didn't intend to harm the employees. She just didn't have the funds at the time when she prepared them, but her plan and intent was to make the payment. Whether that's good or bad, I mean, it was probably not good, but it was what, and so I don't think that she actually had an intent to harm, and she never did, because she did make full
But she
payment.
did have an intent to deceive.
I think we stipulated that she misrepresented to her employees what the pay stub reflected, Your Honor. We did not.
And that's what I'm asking about. Like, I just, can you help me understand how the mental health evidence impacts that particular aspect
Well,
of
I
this
think
case?
when she has manic episodes and she has the inability to recognize what is in the best interest of her business or what she should be doing.
I guess the question just comes back to what Justice Rosen asked, which is you're not contending that the mental health condition prohibited or prevented your client from knowing the difference between what was true and what was not true. And she knew she was reporting false information.
I think as the hearing panel found, and based on the testimony of Goldberg and Iliardi, that they found that her mental state did contribute to the problem, that it did cause her the inability to be cognizant and recognize the misconduct and correct it. And I think they felt, and that's what the hearing panel found specifically, and I think they correctly found it because they heard firsthand testimony from the healthcare professionals that were treating her that said that based upon untreated condition and actually taking medication that exacerbated her problem would create a problem for her to exercise good judgment. And I think that's what, and if you look at the pages in the transcript, you'll see 163 and 164 of Goldberg, or 134 and 135 of Ilardi's testimony, where they provided testimony that specifically addressed that topic about how it could have impaired her past. And again, I'm not here to suggest to you at all that every single day she was impaired, because there were days when she was better than others. I think there's no question about that. And that's why I think we've recognized that there was a misrepresentation as it relates to what happened on these paychecks. But I think the important part is that Brandy Sutton has undertaken an effort to do exactly what we want lawyers in Kansas to do, and that is to seek help.
You've
Counsel.
indicated your client wants to address the court.
Yes.
Before either of you sit down and conclude your presentation, can you tell us what you want us to do?
Thank you, Your Honor. I appreciate it. Well, we believe, Your Honor, certainly that the hearing panel has it right. The probation would be the appropriate measures. It's in place for a year now. It has been working and it is monitored. Mr. Anderson is a terrific lawyer out of Lawrence. He's monitoring it. He is able to, and as the panel found it, the condition is correctable. He's watching the IRAs. He's watching her entire financial condition. He's making sure she's making tax payments. that she's running her firm appropriately, and I think the issues are being addressed. She's being treated, as we've provided the court yesterday, with updated affidavits. She's continuing treatment. She's in the KLAPS program. Lauren Reinhardt is seeing her every 2 or 3 weeks, talking to her about her professional life, making sure she's seeking her professional assistance. And I think she's undertaken every possible measure that you would want an impaired lawyer to undertake in the state of Kansas. And I think, Your Honor, or Your Honors, it would be appropriate to give her the opportunity to show you that she's devoted to getting her practice and keeping her practice intact, and that she did make a mistake, and she recognized those errors, and she's undertaken an effort to correct it.
You've taken exceptions to the hearing panel report. One has to do with not including Exhibit B, that you characterize as her extensive cooperation with the Department of Labor. It's a 1.5-page letter, which I don't think goes to the great extent that you describe it as. But their failure they reference their cooperation, but doesn't include Exhibit B. Do you just want this included, or you're taking exceptions? And the other exceptions just have to do with, as I understand it, is not recognizing her mental condition, basically.
Correct.
And so what do you want, when the Chief Justice said, what do you want us to do? What do you want us to do with that?
Well, with the exhibit that relates to the Department of Labor's letter of no action?
Yeah, for instance.
Well, I believe that that's indicative of what the Department of Labor found, and I would hope that this court would be consistent with that, and that she wasn't deceitful. She wasn't.
But the finding of fact references her cooperation in finding that she's complied with the Department of Labor. Just so.
Correct. And I would hope that this court would agree that she has done everything with the Department of Labor and done everything that they asked her to do to make restitution, to make all of the earnings that were lost from these employees during the failure to make those payments. She's made those payments, and every employee is completely been made whole. And I think that's correct.
And I think the hearing panel finds that.
Yes, I think they recognize that she was remorseful and that she was making every effort possible.
Counsel, let me tell you what I'm wrestling with.
Yes.
I can understand getting behind on the employer contribution, but the employee contribution, that was really a conversion of funds. Wouldn't you agree?
I think
that was their money, and it didn't go where it was supposed to go. It went somewhere else at her direction. So it's not just a misrepresentation on a pay stub. Their money went somewhere else. In my mind, that's a conversion, right?
I think that the funds didn't get deposited because of the financial condition of the firm.
Which means they went to other creditors.
Right, what she did do was, what she could have done was terminated some employees so she could have kept the program. Or as Ms. Knoll said, she could have eliminated the program so that she didn't have to fund it, but she didn't do that. And maybe that's an evidence of bad judgment on her part because of her mental condition, but she didn't do those things, but I don't think that she intended to harm any of the employees.
But it's a conversion. I just think it has to be looked at that way. And I'm not trying to be hard here, I'm just trying to be realistic. Then the second thing you say is she didn't intend to hurt anybody by that conversion. And quite honestly, every lawyer who stands up here and has hit their trust account with client money and applied it to other things always say they intended to put the money back. Now, in her case, she did. Other cases, they don't. But they always have that intent. And so, I've got to balance off what the appropriate discipline ought to be. And, with these other cases. And believe me, I'm all for successful reentry in these kind of things. I mean, I've made the same argument in my life that, you're making right now on behalf of clients. So I'm all there, but I can't get past that this is a conversion. It has to be looked at as a conversion of money in a fiduciary capacity. And that seems to cry out for some kind of real sanction.
And I think probation is a real sanction. I think what she's doing is, I think putting 12 employees on the streets out of a job, putting a lawyer and suspending a lawyer from practice is likely to put her out of a job because she's a solo practitioner for all practical purposes, is a sanction that is not appropriate for this discipline, for this event at all. I think it is more consistent with someone who steals $16 million or someone who forges a document or someone who does something that is egregious, that harm people. In this instance, this was someone who was suffering from a mental illness and impairment that she was troubled by, that impacted her. And I think that she has turned it around and done the things that every lawyer should do and should be given an opportunity to prove that. And I think the sanctions are appropriate as they are currently recommended by the hearing panel, because these were 3 recognized lawyers who did listen to testimony of 3/4 of a day of evidence that was compelling, and I think they reached an informed decision that this court should consider.
This may be a bit of a curveball that you would need to discuss with your client, but there is a middle ground here between the sanction sought by the disciplinary administrator's office and the probation sought by your client, and that would be for the court to impose a suspension, to rule that a suspension is appropriate, but to suspend imposition of it pending successful completion of some period of probation. And we do that in some cases.
Right, I know.
Would
In the
that
case
be-
of Mr. Rumsey, for instance, the court did exactly that, and I think he's undertaken a successful. And Mr. Clothier is another great example where Lou Clothier out of Leavenworth had some significant problems, did exactly what Brandy did, effectuated treatment, went and got better, did the things that you needed to do, and has been successful in going through that program. And I know those are 2 instances where probation was granted by this court and exceptionally appropriate. And this case is exactly a mirror image of that opportunity, I think. And
That
we
sort
would
of
hope-
sanction communicates a little bit more
Right, and I understand.
strongly the
And
disapproval.
if that's the court's position, then that could be, but I'm not sure that it's necessary, because that Brandy is going through the probation and the plan and the documentation the court has for over a year now, that she is effectually going through all this. She's continuing with her monitoring agreement with KLAPS. She's continuing the treatment with her doctors. So she's doing everything that, and has for over a year now. And I think
Have you
that's-
discussed that sort of hybrid with your client?
We've certainly discussed a lot of different concerns about what
Do you
this
know
court
whether that
might
would
do.
be acceptable to her?
And I'm gonna defer to her.
Okay,
And let her answer
alright.
that question, because I think it'd be better to let her answer
Yeah,
it than me.
that's fine.
And she would like to speak to your honors if that's permissible.
It is. How much time do you think she's going to need?
2 or 3 minutes maybe, judges.
Okay, I'll put a hard deadline of 3 minutes on it. All right?
Thank you, your honor. Appreciate letting her speak.
Certainly.
May it please the court. As you know, I'm Brandy Sutton. Did I make an 8.4C misrepresentation? Yes, I did. Did I print pay stubs that showed that monies were being held and monies were being contributed? Yes, I did. Did I go in and physically manipulate each one of those pay stubs? No, I did not. We use QuickBooks. I think everybody uses QuickBooks. And it's set up to where it automatically takes all the deductions, applies all the taxes. I don't do any of that. I simply enter the hours. Did I intend to pay these employees? Absolutely. During this time, my firm was suffering significant financial difficulty. Other creditors weren't being paid. I wasn't being paid. I was doing my best to keep the doors open. Looking back, it's easy to see I wasn't okay. I thought I was getting better. I thought I was taking the right treatment. And then December 24th, 2015, my grandfather passed away. And that was the straw that broke the camel's back. I ended up trying to get help from my professional provider, who kept pushing me off. Finally, he told me, well, I'm retiring. I called KLAP. I called everybody I could think of, everybody I know. I went down the phone book trying to find somebody who could get me in. Maria Lardy finally said, yes, I'm willing to see you in March. I went on her on-call list, and in late February, she finally got me in to see her. And after several appointments, it was determined that I was bipolar, that these blackouts I'd been experiencing weren't blackouts, they were seizures. And I started getting on track. I got back involved in my practice. I talked to KLAP. They helped me look and see that 7 days a week in the office wasn't fixing the problem. It was probably only making it worse. I was trying to get funding. I finally ended up going to my bank, opening a line of credit to get the money to start getting this corrected. I contacted the Department of Labor, knowing good and well they could find me criminally liable for this, and set up a plan with them, worked through not only the employee involved, but every employee for a longer period of time than this was actually involved, to make sure I was timely paying each employee, even in the months I did make payments. Were they done the date it should have been done? Which I thought I had 30 days. I didn't. I had 3 days. So I ended up paying lost earnings to employees who had their payments made, but they weren't timely.
Excuse me, counsel.
Yes.
I had authorized 3 minutes, and I'm willing to be a little flexible, but before you sit down, you need to tell us a response to Justice Byers' question.
I will take whatever this court deems appropriate. I know I was wrong. I have no doubt that I will comply with my probation plan. I understand why it kind of a kicker clause. If I decide not to comply, then I should be subject to some kind of further penalty. But it doesn't concern me. Mark has been great. KLAP's been great. There's some women from QA that have been great. Mark comes in every month, goes over my profit and loss statements, goes over my open line of credit, reviews my employee payroll history, reviews my 941s, reviews my quarterlies, and really takes the time to sit down with me and make sure the firm's on the right track. And if it's not, what do I need to do? What do I need to get profits up? Do I need to let people go? Do I need to change my practice areas? Whatever I need to do to make sure I'm staying on that.
Would you like another 60 seconds to wrap up your presentation?
I would appreciate it if I
All
could.
right.
This has been an experience. I can't say it's been a good one, but it's been necessary for me to really look at the impact of my actions, to come to grips with, firm wasn't doing financially well, I wasn't doing well, and that was a direct contribution to it. I would like the time to thank Ann McDonald. I'd like to thank Lauren Reinhold and Mark Anderson. These are people I'm never going to be able to repay for the time they've invested in me. And I would ask that this court place me on probation. Thank you.
Do we have any questions for counsel? All right. You reserve some time for rebuttal, 3 minutes.
Justice Biles, to answer your question, it was $22,517.30 that DOL said that she needed to pay back. And as far as the timeline, the complainant's first pay stub, July 3rd of 2012, was the first time that it showed up that she was supposed to be getting contributions. The first actual contribution that was made September 19th of 2012. And there was an arrearage at the end of 2012 of $1,269.18. And this is just for the complainant's accounting. This isn't for all of the employees. And then for 2013, the pay stub showed $3,161.42. She actually over deposited for that year. of $773.04, but because there had been an arrearage, there still was an arrearage of $496.14. And then in 2014, it showed $1,500 for the employee contributions and $1,649.96 for a total of $3,297.30, and no contributions were made at all in 2014. And then the deposits started June 28, 2015, after she had received the information from our office and perhaps when she'd received the letter from the complainant. And at the end of 2014, the arrearage was $3,793.44. The hearing panel on page 12 is where they talk about that her mental health issues may have affected her ability to promptly recognize and correct her misconduct. Nowhere in this hearing panel report does it say that there was a substantial direct correlation. I don't believe the court obviously has a record in front of it. You have the transcripts, but the information provided, or the testimony provided by Ms. Goldberg that was cited in the reply brief, was that she had anxiety that was overwhelming and a lot of panic attacks on a regular basis. And yeah, the antidepressant clearly wasn't doing its job because it didn't have the mood stabilizer. There's no direct testimony that says that her undiagnosed mental illness caused her to be dishonest. The same treating professional that I just quoted to you also said that she impressed her because she was able to function throughout this period of time. And so even if there were periods that she had bad judgment, it was almost 3 years worth of this conduct. So also the Rumsey and the Clothier cases don't involve conversion of funds, and that's why my recommendation is more harsh than the outcome in Mr. Rumsey.
Any questions? Seeing none, thank you, counsel. We thank you all for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. Court is now in recess until 9 o'clock tomorrow morning.